Rise. Circuit Court of the Ninth District Circuit, County, West County, Florida is now open. The Honorable Frederick J. Mutton, Chief Judge presiding.
All right, have a seat, everyone.
Good
morning. We are on the record in three matters: 2016 CF 15738, CF 2017 826, and 2017 MM 668. Mr. Loyd, are you Markeith Loyd? Are you Mr. Loyd? All right, very good. Mr. Loyd, my name is Fred Lawton, and I'm a circuit court judge, and I'm handling any cases that flow from your recent arrests. You and I need to do some work together today. Before we get down to work, I want to talk to you a little bit about our relationship, about courtroom procedure, and that is, as I've said, that we have some work that we have to do today and going forward. It's going to require that we work together and communicate, so I want to talk to you first, and I'm going to give you a chance to respond. Mr. Loyd, it's clear that you have been arrested and that you're in custody. The arrests, which I'm going to cover with you in a moment, are for some very serious charges. You are presumed to be innocent of these charges under the Constitution of the United States and the Constitution of the State of Florida. The State of Florida has the burden of proving that you're guilty of any charges that they may formally file against you, and they haven't filed any formal charges against you. During these proceedings, Mr. Loyd, and throughout your incarceration, you have the absolute right to remain silent and not have your silence used against you in any way. I'm not going to ask you about the facts of your case. If you insist on talking about the facts of your case, anything that you say can be used against you. I want to advise you, Mr. Loyd, that we're recording these proceedings, that the state of Florida can get a copy of anything that you say, can get a copy of these proceedings, and could use what you say about your case if you insist on talking about the facts of the case. So you don't have to talk about the facts of the case, and I would strongly advise you not to talk about the facts of this case. But at this point, procedurally, if you insist on talking about the facts of your case, there is virtually no way that that can help you, and that it can only disadvantage you, and I want you to be aware of that, Mr. Loyd. I also want to state this, Mr. Loyd. I and the other individuals in this courtroom, including the clerk of the court, the deputies, the court reporter, the attorneys, I intend to treat you with respect and dignity because you're owed that as a human being. I don't intend to be rude or disrespectful to you, Mr. Loyd. I need that same behavior from you. If you choose to curse at the court or treat me or others disrespectfully, then you're going to make it very challenging for others to treat you with respect. And I want to ensure that that happens. So I'm not going to curse at you, and I'd ask you not to curse at me or others. And Mr. Loyd, we're here today to talk about your decision to represent yourself. And I want to tell you, and I'll go over this in a little more detail later, that if you cannot comply with these rules of courtroom decorum, and that you insist on using language that's inappropriate, then I could deny you your choice at self-representation. And if that continued, I could remove you from the courtroom so that you wouldn't even be present during your own trial. That's something I would not want to do, but to ensure that that doesn't happen, I need some cooperation from you. Mr. Loyd, there are times like now when I need you to listen carefully to me and to respond to me, not about the facts of your case, but I want to tell you that in turn I'll listen to you when it's your opportunity to talk, but we can't both be talking at the same time. And I appreciate that right now you're listening to me. And if we talk over one another, then we're going to waste time. I'll waste your time, you're going to waste my time, and I really dislike wasting courtroom time. Mr. Loyd, do you have any questions so far? No? Okay, very good. So, Mr. Loyd, we're here to talk about the charges for which you've been arrested. And as I said earlier, you have not formally been charged with anything yet. That's up to the state attorney's office. You've been arrested. You're in the custody of the state, but no formal charges have been filed against you yet. Yet, you are entitled to the services of an attorney. If you cannot afford to hire your own attorney, then one would be appointed to represent you at no cost to you. Or you can choose to hire your own attorney if you can afford to do so, or you could choose to represent yourself Although in a moment I'm going to talk to you about some dangers and disadvantages that occur when you choose to represent yourself. So we're going to do that in a few moments. But let me first review the charges with you to make sure that you know what the charges for which you are arrested are. And they're in 3 separate cases. In 2016 CF 15738, you've been arrested on 5 charges. They are first-degree murder with a firearm. You have no bond on that charge. If the state attorney files that charge against you, the maximum penalty, if you are convicted of that charge, is either life imprisonment or death. The second charge listed in the arrest affidavit is unlawfully killing an unborn child by injury to the mother. That is also a capital offense, so the maximum penalty is life in prison or death. And you have no bond on that charge. The third arrested charge is attempted first-degree murder with a firearm. That charge, because it alleges use of a firearm, is classified as a life felony. You have no bond on that charge. The fourth and fifth charges listed are aggravated assault with a firearm, and they're both punishable by 5 years in prison. In 2017 CF 826, you were arrested for first-degree murder, a capital offense punishable by life imprisonment or death. You have no bond on that charge. Also attempted first-degree murder of a law enforcement officer, which is punishable by life imprisonment and for which you have no bond. You are arrested for carjacking with a firearm, which is punishable by life in prison and for which you have no bond. You are arrested for aggravated assault with the intent to commit a felony, which is a third-degree felony punishable by up to 5 years in prison and for which you have a $20,000 bond. Possession of a bulletproof vest while committing an enumerated offense, which is a third-degree felony, punishable by up to 5 years in prison and for which you have a $10,000 bond. And I understand that yesterday you were arrested for resisting an officer without violence in 2017 MM 668, which is a first-degree misdemeanor punishable by up to 1 year in jail. Mr. Loyd, as you, I'm sure, know, these are very serious charges and charges for which you potentially could be executed in the state of Florida. As I said, you have the right to be represented by counsel. If you cannot afford to hire an attorney, one would be appointed to represent you. The state of Florida will pay for a lawyer to represent you in these cases. And so my question, Mr. Loyd, is do you want me to appoint an attorney to represent you in these matters? All right, I'm required then to have a conversation with you, Mr. Loyd, about that choice. So I want to go through this with you. It's going to take a little bit of time. And I appreciate your patience while I go through it. Mr. Loyd, do you intend on hiring an attorney to represent you, or is it your plan to represent yourself?
I don't know, since I've been beat, they never talked to nobody. I haven't talked to my family, I haven't got a phone call, I haven't took one shower, I haven't did shit. They beat me in my eye with a pistol, with a gun, and they knocked my eyeball out. I'm losing my eye. I can't open my mouth and eat. I don't know what's going on. So,
all right, so let's talk.
I really don't even want to talk to me because they bring me here, beat me, don't give me no phone call, don't give me no shower, don't give me shit, and I will come in and talk to y'all.
Mr. Loyd, let's talk. Well, in a way, we have to talk to one another. So let's talk about what you just mentioned to me. Is it that you have not decided to represent yourself, you just haven't been able to talk to your family about hiring an attorney? Would you hire an attorney if you could talk to your family?
I don't know. I ain't there talking about it.
Okay. So I am going to direct the jail to allow you to make a phone call to a family member to discuss whether or not there are plans for you to hire, you or your family, to hire an attorney to represent you. I'm going to order that they do that today. If you haven't decided that you want to represent yourself, you're weighing whether to hire an attorney or represent yourself, we can wait and have this conversation about representing yourself down the road. If you're thinking that, yes, I need an attorney, but I want to hire my own, and at this point I don't want the court to appoint a public defender to represent me. Is that where we are? That you might hire an attorney?
I don't know.
Okay. So if I ask you, is it your desire definitively to represent yourself, you haven't made that decision yet?
For now, I am.
Is that because you can't communicate with people, or is that because you know you want to represent yourself?
Both.
Okay. Well, let me go through with you points that we have to cover today and going forward if you choose to represent yourself. Although it's a little unclear to me whether you're absolutely making that choice, so bear with me for a moment. Mr. Loyd, I don't know whether you know this, so it's my obligation to inform you of it. A lawyer's legal knowledge and experience may favorably affect any pretrial release possibilities that you might have, may result in obtaining information about your case through the skillful use of discovery devices, may uncover potential violations of constitutional rights and take effective measures to address them, may ensure compliance with speedy trial rules and statute of limitations provisions, and may identify and secure favorable evidence to be introduced later at trial on your behalf. Mr. Loyd, let me ask you a couple of questions about procedures that I know would happen in a trial. And let me start with this, Mr. Loyd. If you represented yourself and you were in the jury selection portion of the trial, which is called voir dire, you are entitled to certain peremptory challenges, that is, challenges for which you don't have to provide a reason to the court. Do you have any idea about how many peremptory challenges you would have for a capital felony or any other felony?
Nope, that's my job to learn.
All right, but you don't know that right now, Mr. Loyd. Is that fair? Okay. Mr. Loyd, do you have any idea when in the course of the trial you would have to move for a judgment of acquittal, or you would waive the right to argue on appeal whether there was sufficient evidence introduced to convict you? Do you know at what point in the trial you'd have to do that? Apparently not. All right. Do you know what a motion for judgment of acquittal even is?
Yes, but I'm asking the question. What's all this?
Well, this is to demonstrate for you that a lawyer would know these questions easily. And one of the disadvantages of representing yourself is I can't be your lawyer for you. And so if you don't know when to make a motion for judgment of acquittal, you might waive important rights. Are you familiar with the rules of evidence in the state of Florida? So, Mr. Loyd, the point is that a lawyer with about 3 weeks of experience would have no trouble answering these questions for me. The prosecutors, they certainly know the answer to these questions. And I want you to think carefully about how you could compete fairly in a trial with a lawyer on the other side who's been to law school, who's tried cases, who can answer these questions in his or her sleep, and would have no difficulty immediately providing me answers to these very basic questions. Mr. Loyd, I can't tell you how to present evidence. I can't call witnesses for you. You would have to figure all of that out on yourself, and that's a pretty daunting task. Let me talk to you about a few other things that a lawyer can do to you. A lawyer has the experience and knowledge of the entire trial process. A lawyer can call witnesses on your behalf. A lawyer can question any witnesses who testify against you. A lawyer can present evidence on your own behalf. A lawyer could advise you about whether or not you should testify, the consequences of that decision, what you do and don't have a right to say, and review with you your absolute right to remain silent. A lawyer has studied the rules of evidence and trial procedure, and they know what evidence can or cannot come into your trial. A lawyer would assist me, the court, in ensuring that the jury is given complete and accurate jury instructions in your case. A lawyer could make effective closing arguments on your behalf and prevent improper arguments if the prosecutor were to make them. Mr. Loyd, a lawyer would ensure that any errors committed during the trial are properly preserved for appellate review later by a higher court. If you fail to make timely objections that are specific, then those errors would be waived. Mr. Loyd, it's almost always unwise to represent you in court, and there are some other disadvantages of representing yourself, and I want to review them with you. Do you understand that you will not get any special treatment from the court just because you're representing yourself? Do you understand that, Mr. Loyd?
I just get my eye out, so I ain't get no special treatment.
We'll cover that in just a moment if you'll bear with me. Do you understand that you won't be entitled to a continuance simply because you wish to represent yourself? Do you understand that, Mr. Loyd? That your case wouldn't be continued just because you say, well, I'm my own lawyer and I want more time? All right. Appears you don't want to answer that question. Mr. Loyd, you clearly would be limited to legal resources that are available to you while you're in custody. You wouldn't be entitled to any additional library privileges just because you're representing yourself, and a lawyer certainly has none of those restrictions in researching your defense and the law that applies to your case. Now, Mr. Loyd, you're not required to possess the legal knowledge or skills of an attorney in order to represent yourself, but you will be required to abide by the rules of criminal law and the rules of courtroom procedure and decorum. These laws took lawyers years to learn and abide by, and if you demonstrate an unwillingness to abide by these rules, then I could terminate your choice at self-representation and require that an attorney appear on your behalf. Do you understand that, sir? All right, for the record, it appears Mr. Loyd doesn't want to answer my questions right now. Mr. Loyd, I want to advise you that if you're disruptive in the courtroom, that I could also terminate your right to self-representation and in fact go as far as removing you from the courtroom, in which case your trial would consider or would continue, without your presence in the courtroom. A lawyer would have unrestricted access to the state attorney who's prosecuting the case, but you will be severely restricted as compared to a lawyer in your ability to contact the prosecutors who are trying your case. In addition, I'm required to advise you that the state won't go any easier on you or give you any special treatment because you're representing yourself. And trust me that a very experienced prosecutor will represent the state in the case against you. And finally, and perhaps most importantly, Mr. Loyd, if you are convicted and you represented yourself, you cannot claim on appeal that your own lack of legal knowledge or skill is a basis for a new trial. In other words, you cannot claim that you received ineffective assistance of counsel since you will be acting as your own lawyer. Mr. Loyd, do you understand these dangers and the disadvantages of representing yourself? Do you have any questions for me about them, sir? All right, for the record, Mr. Loyd is shaking his head no. Mr. Loyd, do you understand the charges that I reviewed with you earlier for which you've been arrested? Do you understand those, Mr. Loyd? That's just yes or no. You either understand them or you don't, Mr. Loyd. And if you don't, I'm happy to answer any questions you have. So do you understand the charges, sir? All right, for the record, Mr. Loyd doesn't want to answer that question. Mr. Loyd, the state has not yet filed formal charges against you. If they do, I will review them with you when and if they file any charges against you, and I will again review with you the penalties. Now, Mr. Loyd, I need to ask you a few questions about yourself to determine if you're competent to make a knowing and intelligent waiver of counsel. How old are you, Mr. Loyd? 40? Did you say 40 or 41? I'm sorry. 41. Mr. Loyd, how far have you gone in school? All right, sir. Can you read and write English? How many years of formal school did you complete? 10? All right, thank you, sir. Mr. Loyd, are you currently under the influence of any drugs or alcohol? In other words, are you taking any medications in jail right now? Do you know what you're taking? Codeine. Is that for injuries? All right, sir. Mr. Loyd, have you ever been diagnosed or treated for a mental illness? Do you have any physical limitations, and this is where I want to talk a little bit about your eye. Do you have any physical limitations that would restrict you in your ability to adequately represent yourself? Let's start with, before we get to the condition of your eye right now. Are you able to hear clearly what we're talking about right now? Can you hear me all right? In other words, can you hear the volume at which I'm speaking? Or not? You want to think about that for a minute? Mr. Loyd, it appears to me that you can only see out of one eye. Is that affecting your ability to read? In other words, if you were representing yourself in your current physical condition, could you physically perform the task of reading documents and listening as evidence is being introduced against you? All right, let's move on from that one. Has anyone told you not to use a lawyer? Has anyone threatened you if you hire a lawyer, Mr. Loyd? Do you understand that a lawyer would represent you for free? All right, for the record, Mr. Loyd just refuses to answer the last 3 or 4 questions that I've asked. Mr. Loyd, let me ask you this. Have you ever represented yourself in a trial before? All right, Mr. Loyd won't answer that question. Do you have any questions about having a lawyer represent you, Mr. Loyd? All right, for the record, I want to make the following findings of fact. Mr. Loyd is 41 years old. He indicated that he understands English, that he has his GED, that he's completed 10 years of school. There are times in these proceedings when Mr. Loyd will communicate with the court, and when he does, he appears to comprehend what the court is talking about. And then there are other moments where Mr. Loyd just refuses to answer the questions that the court is asking of him. It's my job to determine today and going forward at each material stage of this trial whether Mr. Loyd is competent to represent himself. His behavior today is appropriate to the proceedings. He has indicated that he is upset about his eye and his physical condition. He appears to understand what's happening in court today, but has decided just to stop participating with the court in the proceedings. For the moment, but for only this moment, I find that Mr. Loyd is competent to make the decision to waive counsel, stating for the record that the decision of the court is not whether Mr. Loyd can competently be a lawyer or perform the services that a lawyer would perform on his behalf, but whether he is competent to waive a lawyer's representation of him, that is, whether he is knowingly, intelligently, and voluntarily choosing to waive his right to counsel. And right now I find that he is. Mr. Loyd, do you want me to talk to you, if now or later, about what a standby attorney would do on your behalf? You want to talk about that today or later?
I'll talk to you later.
Okay. So, at the present time I'm making that finding, Mr. Loyd, that I have some limited information, but the information that I do have makes it appear that you're competent to choose to represent yourself. I want to advise you of this, Mr. Loyd. If the state files formal charges against you, then you're entitled to an arraignment where I advise you what you've formally been charged with. We will review this choice once again, and then we would set pretrial and trial dates on the case. So we'll be bringing you back for that proceeding. In the meantime, I hope you'll carefully consider what we talked about, and I would urge you to consider having a lawyer represent you, because these are charges, as I said earlier, for which the punishment could be life in prison or execution by lethal injection or otherwise. So the charges are very serious, and I would hope that you would carefully consider allowing the court to appoint counsel to represent you. But ultimately, Mr. Loyd, it's your choice. It's not mine. It's your choice. And I'm going to respect your choice if it's knowingly, freely, and voluntarily made. I am going to order the jail to give you access to a phone so that you could contact family members to discuss with them whether there are any activities on your behalf to hire private counsel to represent you. When you're talking to your family, Mr. Loyd, I want to remind you of the fact that those phone conversations could be monitored, so if you talk about the facts of your case, you're doing that at your own peril. But talking to your family about, do you plan to hire a lawyer to represent me or have the funds to do so, you can do. But I would advise you not to get into the facts of your case. If a lawyer is hired to represent you or appointed to represent you, the conversations that you have in private with your lawyer are privileged and cannot be disclosed with very few exceptions. And I want to advise you of that fact. Mr. Loyd, do you have any questions of me at this point, sir? I'm sorry, no? Okay. All righty. So, as I said, we'll wait to see if there are formal charges filed. If they're filed, we'll set an arraignment. At that point, I will review with you once again your choice for self-representation. Mr. Loyd, so you know, in case you hear this term, the inquiry we just had is called the Ferretta Inquiry because there was a case from the United States Supreme Court where Mr. Ferretta was a party. I'm required at all material stages to review this matter with you, and it takes a lot of questions and patience, and I think you've been patient today. And we're going to have to do this more than once is what I perceive. Okay, thank you very much, and we're in recess at this time.
All rise. Court in recess.